Greetings, family. I'm Advocate pulengmatshelo. If you are new to this channel, you are welcome. If you are not new, welcome back again. I just want to say thank you very much for subscribing to our YouTube channel. To our new subscribers, please, we have more than 50 something videos that we have uploaded. Go back and just consume the material and comment, make suggestions to us as to which topic you want us to handle. And please share the information so that we inform, we educate our nation. This is, by the way, legal education. It is not legal advice. It is not legal opinion. If you need a legal advice or legal opinion regarding your case, you can consult a legal practitioner to help you with your case. Now today, I will be discussing how to draft a valid will. This is now a topic on the law of testate succession. Last time we discussed interstate succession. Interstate succession being a position whereby you die without drafting a will. Now today we are looking at testate succession, how to draft a valid will. This situation is regulated by an act called the Wills Act number 7 of 1953. You can Google and I think you'll be able to get it. I will just give you a summary of that act, just so that you should be a bit enlightened, because it is very important that before you pass on, you draft a will. And the person who drafts a will obviously is called a testator, and a will is that document that expresses your wishes as to what should happen to your belongings, to your possessions, to your property after you pass on. Because a will, this very document, only becomes effective at the time of your passing on, after you've passed on. But as long as you're alive, it cannot be implemented. I guess that is why it is a will. The reason why it is important to draft a will, amongst others, there you have expressed your wishes. Everybody around you gets to know what you want to happen to your belongings. Secondly, this is to avoid or to minimize conflicts, because in most instances when people die or when people pass away, you'll have lots of fights about who should inherit what. So once you have expressed your wishes, your desires regarding your property in a piece of document, in a legal document, then there will be less conflict or no conflict at all. Now it takes me to the issue of this will must be valid, because you must remember the will can be challenged and a will can be nullified if it does not meet certain requirements, which I'm about to outline. And those requirements are, number one, this will, it must be in writing. By in writing, obviously means that you can write it, just use a piece of pen, a pen, like the one that I have in my hand. You can write your will like that, or you can get it typed. And the person who qualifies to write a will, by the way, I'm talking about the requirements. This person must be over 16 years of age. And this will must be signed. All pages must be signed, from page 1 to page to the last page. It must be signed by the testator being the person who has drafted it. And this will must be signed in the presence of 2 witnesses. And these witnesses, both of them, they must be above the age of 14. And they must also sign. And all the signing must happen in the presence of the testator and the two witnesses. The testator can just take a will and say, okay, I will send it to another town, I will post it via whatever, and then you can sign it and then you can return it. No. Everybody must be present when this will is signed. Perhaps you can draft it in their absence, but when it comes to the signing part, everybody must be there. And for it to be valid again, there must be a clear intention that this is what the testator wanted, that he was not forced. If there can be an indication that somehow he was forced. I've heard of stories where people were made to sign a will on the deathbed when they are no longer in their right state of mind. Because capacity, mental capacity, is also important. That this person was in his right thinking, he was of the appropriate age, he was above 16 above, if he's a testator, he's 14 plus, if he is a witness. That takes us to the issue of a competent witness. That's why they talk about a competent witness. The competent witness is the one who is 14. Now, another important thing is that during this process, or after the will has been drafted rather, the master of the High Court is somehow get involved at the time when the will is interpreted and implemented. Because the master of the High Court is the one who oversees the administration of all deceased estate. He's the one who has been given that authority. He's the one who has to interpret this will. He's the one who has to read this will, to see to its implementation, to ensure that this will meet all the requirements in terms of the Wills Act. Now, this is why it is important that the will must be done by people who are qualified, unless if we know you are sure that you will do the right thing. Now, it takes me to the topic, who can draft a will? You yourself as a testator, if you are the testator, you can draft a will. A will can be drafted by a lawyer, an attorney. A will can be drafted by a financial advisor who is obviously trained. And it can also be drafted at a bank, by a bank. So it's you, it's an attorney, it's a financial advisor, it's at the bank. That is why you see financial institutions, because they have financial advisors. Some of them are trained to draft a will. So you are better placed to ensure, it's very, very important to ensure that your will is valid. Because I know that the emphasis has been drafting a will, but the question is it a valid will? So you need to ensure that all these requirements that I have outlined, they are met by your will. Another important thing, and the last thing that I need to mention, is that you must update your will. From time to time, when there are new situations, when there are changes in your life, probably at the time when you wrote a will, you had one child. At a later stage, you have two. Change the will to include this child, if that is your intention. Because you must remember that the will is about expressing your wishes. After you have had four, you've had every time when there is a change, when you divorce, change your will. Because probably you would have included your spouse. The law gives you only 3 months after your divorce to change your will. If after 3 months you don't change it, there will be an assumption that the intention was to include that ex-spouse. So it's very important that we should be prompt in terms of visiting our will, in terms of updating our will from time to time, depending on the change in your circumstances that would make you to want to change it. It's very important. I hope this was helpful, and thank you for listening to me. Please share this information. Please comment and let me know which areas you want me to teach on. And please subscribe and press the post notification bell, so that when we upload, you get to know. Thank you very much. God bless you.